Welcome to the Scaringi Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. A prominent trial lawyer, Robert Barnes, has threatened to sue the New York Times reporter Maggie Haberman for libeling Nick Sandmann and the boys of Covington Catholic High School. Scaringi Law has offered to assist in this lawsuit. Is Maggie Haberman of the New York Times, is she liable? A lawsuit will be based upon the tort known as libel. A libel is any malicious publication which is written, printed, or procured to be written, and which tends to expose a person to contempt, ridicule, hatred, or degradation of character. Now, to succeed in a libel suit, Nick Sandmann or the Covington Catholic schoolboys must show harm resulting from the media's publication of defamatory material. Sandmann may recover for any injury done to his reputation, which may include impairment of reputation and standing in the community, personal humiliation, mental anguish, and suffering. Do you think Sandmann can prove any of those injuries? I think so. The New York Times was one of the many patently false stories about this incident. These media stories caused an avalanche of death threats and claims that Sandmann and his friends were racists, bigots, Nazis, should be killed, should be removed from this world. The security of one's reputation or good name from detraction and slander is a right to which every person is entitled by reason and natural justice. And the Pennsylvania Constitution, for example, declares all men are born equally free and independent and have certain inherent and indefeasible rights, among which are those of enjoying and defending life, property, and of acquiring, possessing, and protecting property and reputation, and of pursuing their own happiness. So reputation and the right to it is put there right in the Pennsylvania Constitution. Now, the New York Times will defend the lawsuit on the grounds that matters of public interest and concern constitute news and may be printed with impunity. The news privilege, so to speak. But that privilege only applies when it is a matter of public interest and concern and when it's accurately stated. In the case involving Sandmann and the Catholic schoolboys, that privilege will likely not apply. First, the media reports about this incident are riddled with inaccuracies. Second, this matter may not have been a matter of public or interest of concern. No one involved is a public figure. The only reason it became news is because the media chose to make it news so that they could defame the Catholic schoolboys. But even if it was a matter of public or general interest, the law will not protect the publishing of defamatory falsehoods. The United States Supreme Court has ruled that a newspaper or broadcaster publishing defamatory falsehoods about an individual who is neither a public official nor a public figure may not claim a constitutional privilege against liability for the injury inflicted, even though the falsehoods concern an issue of public or general interest. Again, the report of the transaction must be fair and true, for an unfair and exaggerated report may work a forfeiture of the news privilege. Now, of course, these media reports are riddled with unfair and exaggerated reports about the incident. Just take one example, the New York Times article that was tweeted out by Maggie Haberman was written by Sarah Mervosh, June 19, 2019. In the article, she writes, jeering high school boys, predominantly white and wearing Make America Great Again gear, so of course that makes them evil, surrounding a Native American elder. Now, there were no jeering high school boys surrounding the Native American elder. The Native American elder injected himself into a group of high school boys who had been chanting school rally pep songs. That's the truth of the matter. The Times got it patently false. It continues, across the country, Mr. Trump's name and his campaign for a wall on the southern border with Mexico have been used to goad minorities, including by high school students at sporting events. Any proof of this? None. Not one, no proof. She just makes the statement. She does it because she wants you to think that, oh, here we are again, high school students wearing MAGA hats, using Trump Build the Wall to goad the minority, Nathan Phillips, the Native American. It's absolutely false. It was Nathan Phillips, the minority, who goaded the white high school MAGA hat wearing boys. It's just the boys didn't accept the goading. The article quotes Sisters of Mercy, a group of Roman Catholic women who condemned Sandmann and the Covington High School Catholic schoolboys in the videos as bigoted. quote, racism and intolerance in all forms go directly against Catholic social teaching. So the New York Times brings in Catholic women to condemn the Catholic boys, Nick Sandmann and his friends, as racist bigots, when those boys did not utter or exhibit any racist or bigoted behavior. In fact, the racist and bigoted behavior came from Nathan Phillips' group and the Black Hebrew Israelites, who uttered the worst, vilest insults one would ever want to hear, the Black Hebrew Israelites. And Nathan Phillips' groups, when they injected themselves into the group of boys, one of Phillips' cohorts was telling the boys that this is indigenous land, America, and these boys are basically trespassing here because they're white European descendants, and they need to go back to Europe. That's kind of racist and bigoted. So the New York Times got it patently false, and they reversed the bigotry and racism and took it off the minorities and put it on the white kids. The New York Times also quotes Phillips as saying, "I started to go that way, and that guy in that hat stood in my way, and we were at an impasse. He just blocked my way and wouldn't allow me to retreat." Patently false. Nathan Phillips walked in from 20 yards away, where he was standing off to the side, into the group of high school boys, shuffled around, and then stood in front of Nick Sandmann, and didn't leave Nick Sandmann. He beat his drum, sang his song directly in Sandmann's face, inches from Sandmann's nose. Phillips made no attempt to move to the left, to the right, or backwards. He wanted to make a point, and he wanted to goad Sandmann. That's why he was there. Everything he said at the Times, patently false and easily proven by watching the videos, which the New York Times either didn't do or did and ignored. Phillips is quoted as also wiping his eyes. He was weeping when he said this. "I heard them saying, 'Build that wall, build that wall.'" Patently false. Not one video shows or presents any audio of the boys chanting, "Build the wall, build the wall." They were chanting their school pep song. Maggie Haberman's tweet, it states there are dozens of students laughing and egging on the behavior. Egging on the behavior. Now the behavior was Nick Sandmann standing quietly, poised, showing self-control, smiling, while a Native American man is beating a drum inches from his nose. Is that bad behavior, vile behavior, racist or bigoted behavior? No. And where's the egging it on? Did you see the videos depicting the boys saying, "Hey Nick, stand there quietly, poised, and just smile"? All of this is patently false. It's all made up by the New York Times, by Maggie Haberman, by the Sarah Mershoff, the author of the article. So I think it's highly likely that Maggie Haberman, the author of the tweet, the author of the article, and the New York Times itself are vulnerable to a libel lawsuit. And this is only a light example. There are many worse examples from CNN, MSNBC, and other liberal media outlets. Now, no lawsuit has been filed yet, but if one is filed, I will certainly keep you advised of its progress. That's about all the time we have today for the Scaringi Law Lunch Break. I hope you learned a little bit about the law. Thanks for listening, and enjoy your lunch.